Senator Irungu Kangata. You remember he is one of the leaders who was on the forefront giving opinions about how the BBI initiative was being viewed by a section of Kenyans, and here he joins me live to just give us his views on what has transpired and what he thinks of the move. Karibu sana, Bwana Senator. Briefly tell us, what is your take on this ruling that has happened just this evening?
First, I'm very happy at a personal level. I had, in January this year, told the president that this process was going to fail. But I was not listened. Instead, I was kicked out for no good reason. But and people thought after BBI passed in the National Assembly, in the Senate, and in the counties that I was on the wrong side of history. But clearly, I had, by God's chance, read the signs of the time, and this process is now dead. And for me, it shows the importance of leaders listening to each other. Because if the president had listened to me, he will definitely not be in this kind of situation. And what I had said in my letter is, we need to focus more on healthcare, on education, on uplifting our farmers, not on altering our constitution.
But coming to the ruling this evening, what would you say the ruling has been, and what stood out for you in the whole ruling?
Several grounds were cited by the court, but you would see in majority of those grounds there was no concurrence, except on one major issue, which is the president does not have power to initiate a popular initiative under Article 257 of the Constitution. And that captures the gist of my letter, which was basically is that this process was not really Mwananchi driven. As a result, Wananchi did not feel this process, and they felt it as if it was an elite notion. Remember, I had said that the government was using provincial administration to push through this process. But the problem with the people who are pushing this BBI thing is hubris. Instead of acting in humility, listening to leaders who wanted to enrich the process, they kicked us out. But I'm happy. I'm now on the positive side of history, which said BBI is going to fail, and it's now dead.
That is on the matter of the popular initiative. What would you make of the ruling pertaining the quorum and the IEBC issue?
Of course, again, it's clear under IEBC Act, the quorum of IEBC is 5 commissioners. Currently, they have 3 commissioners. So therefore, I agree with the judgment that IEBC does not have the correct quorum. Of course, people may ask, okay, what happens to the by-election that have been held? But that's not an issue that was being considered here. It was an issue of quorum to conduct matters referendum, and for me that is finding that issue of by-election is a separate and distinct issue that IEBC needs to check.
Moving forward, Mheshimiwa, what should Kenyans expect? Are we going to see other initiatives now that this one is rested, possibly? Are we going to see any other initiatives geared towards amendment of the Constitution?
I don't know. It depends on various parliamentarians or other actors who are interested in changing the Constitution. Definitely, at a personal level, I would advise against such kind of a move. Let us concentrate on key issues that affect the Mwananchi. For instance, are our counties providing good health care to the Mwananchi? Millions, thousands of Kenyans are dying currently because of COVID-19. Are we vaccinating enough Kenyans? Why expend energy and money on changing the Constitution instead of using that money to support the poor Kenyans? What about education? How many Kenyans have lost their jobs currently because of COVID-19 containment measures? That should be the focus of this republic, not trying to undo the gains that we got in Constitution of 2010. Yes.
And now that we know the proponents as well as those that were dissenting are in equal measures, what would be your advice to the both camps as we move forward towards 2022 general elections?
Personally, as a senator for Murang'a, I would want my people of Murang'a to be united, yeah, despite this process which has been so polarizing. And secondly, I would urge leaders, we now focus on building Kenyans, putting money in people's pockets. It is joblessness that is affecting Kenyans. It is not constitutional change. Yeah. So I urge leaders to concentrate on uplifting millions of Kenyans who are in poverty, not on altering a very good document called Constitution of Kenya 2010. Let's think about farmers. Let's think about healthcare. Let's think about unemployment. To me, once we do that, we will definitely go far as a country, but not on wasting money on trying to mutilate our constitution. Thank you.
Thank you very much, Mheshimiwa. Shiro, like you have heard from Mheshimiwa Senator Irungu Kang'ata, he has been on the forefront among those people who had expressed their views, dissenting views on this matter of BBI. And just to continue enlightening our viewer on what this exactly means, I would wish now to be joined by lawyer Kithi, if he can kindly join me. Thank you very much, Wakili. You can move here so that thank you for making time for K24. We are live. First of all, from a lawyer's perspective, what do you make of this ruling?
Well, truth is, it is a decision which is well reasoned. It has analyzed the issues that were before the judiciary, the Court of Appeal. The judges have taken their time to look into the issues, delve into them, and there was depth, there was thinking, there was analysis, and there was jurisprudence that was created. It was historical to the extent that it was a time of controversy that seems to have been settled in a manner that was controversial. At times a decision is made by the judges, and people look there more separated, and more importantly is that it has cooled down temperatures in the country. I think the reasoning, people walked through the reasoning. It was in an open court. It was properly broadcasted. It was broadcast around the entire country. And I think it has settled a few issues. I do know that that's not the highest court. It's not the apex court. But again, the Court of Appeal has acquitted itself in the most settling manner. I also say with profound respect of the Court of Appeal that the time taken also to persuade itself and acquit itself has been reasonable. I do not think they will have done what they have done in a shorter period. They were calm enough to ask for more time, and were not, did not follow through the panic of the time and the excitement of the time and the controversy of the time. I do know that probably some, as has happened before, courts have rendered themselves in a shorter period, but not in reasoned and progressive decisions. So this is very good. I think it's also trying to settle our jurisprudence, and more importantly, the future looks more settling for our courts. It has improved the confidence that we have in the courts.
One may ask, are we likely to see this proceed beyond this level of the appeals court?
What happens with us lawyers is that we, at the spur of the moment, it may be unsettling to make a pronouncement as to whether there will be an appeal or there may not be an appeal. But eventually, when you sit down and look at the decision, you read to the fine and thin areas of that decision. And the finesse of it is that you begin to pick out some things that were not properly observed. For instance, in this journey, you need to look at what the High Court said and whether everything has been captured in the manner that ought to have been captured. When you're in the Court of Appeal, again, you look at the issues and see whether the reasoning is in consonance and a constant to establish jurisprudence, especially the context of our constitution and other jurisprudences and other jurisdictions. When then you realize that there's some inconsistency somewhere, you may then be inclined to file an appeal. The right to appeal, again, is a constitutional right which cannot be alienated. And therefore, I do think that this controversy may not be completely settled now. And personally, I would love to see it sit somewhere else, debated, so that the issues are settled with completeness, so that then the country moves forward, at least in that aspect of law.
You know, we have had those that were on the forefront, the proponents of BBI that were on the forefront, having shown willingness to move on and to drop the matter altogether. What is the position, and what would necessitate this moving to any other level if their position is that they move on?
My take is this: BBI was BBI because of next elections. Now, because there is limitation of time to this extent, limitation of time to the extent that we are already out of time. Any of these reforms, some of these reforms proposed, ought to be done 12 months before the general election. We are already in the final leg, the final year, and therefore, in terms of limitation of time, we cannot use the decisions or the outcome of BBI, even if we went for referendum, in the next general elections. And therefore, the interest as was there and the urgency that was there was because of the next general election. So to pursue a reform that is expensive, that is time-consuming, that is destructive, and that is emotive, when the concentration should be into winning the next general election, doesn't make sense. So it doesn't make an economic decision, an economic pursuit, for one to pursue the BBI journey when in effect there is a lot to do with the next general election. Those that are competing again is to become more competitive because you give them space and you sit ground. And I do think that is the reason informing the fact that parties would want to concentrate and consolidate their grounds and move to elections and election mode and harness their resources towards that end, as opposed to the journey towards pursuit of BBI. There's another chance for BBI, especially after the next general election.
Just before I let you off, there's this matter that has come out about the IEBC and the quorum and all that matters around IEBC. What would you make of that?
I don't think it's completely a surprise. This decision has already been made. Remember the Ngilu case, and when there was a debate before court as to the quorum for EACC. I think that reasoning there becomes a constant today. And if a commission that reasons as a human being or a person, a legal person, but it does so through a certain quorum, is incapacitated because of lack of quorum, then it means the decisions that are made also are not legal decisions. The Constitution and the composition of IEBC was supposed to be a certain set number of people. If that set number of people then is less in terms of composition, let alone quorum, in terms of composition, then it becomes illegal for any decision to be made by an incapacitated legal person. If you lack capacity, for instance, you are insane, you can't make decisions. If you lack capacity because you're a minor, you can't make decisions. If you lack capacity as a corporate body because you are not properly composed in terms of the numbers of the people who are supposed to act on the issue, then you cannot legally act. Again, there was the issue of quorum. If you do not have quorum to make a decision, then you don't have capacity to make that decision. That's a dual issue that I think was controversy that seems to have been settled to the extent of the decision of the Court of Appeal.
What does this say about any activities that have been rendered by the IEBC as constituted?
I think it will be far-reaching. I'm not sure immediately what happens to the elections that have been made, but if I was the lawyer for any person who probably lost out on a by-election on this account, I will pick that as one of the grounds for petitioning and setting aside that election because it was supervised by a body that was not properly capacitated.
This matter about the character of the president leading a popular initiative. What did you make of it?
Oh, that was a close shave. The president was pronounced as having pursued an illegal transaction. He had in fact been pronounced to have breached the Constitution. Now, how he has escaped is because there was no evidence that he was served with the papers. Now, that's a narrow escape to this extent that if there was evidence or there have been submissions on whether there was service on the president or not, but not service alone, whether he had knowledge of the matters before court, then probably the conviction that was in the High Court will have continued to stand. However, the pronouncement that continued to stand was that the president did not have powers to initiate a popular initiative, so he is not a Wanjiku, he is the president of the Republic of Kenya and commander-in-chief. That pronouncement, although some of the pronouncements against the president have been set aside, that type of pronouncement remains a constant and still binding against the president and his handlers. Yes.
Thank you very much, Wakili, for your time, and I appreciate so much. Wanjiru, like you've had it, I couldn't have put it in a more better way than those that understand the Constitution, those that understand the law, and they have put it into perspective. I am very sure that our viewer has gotten insights from that particular interview. Like we said, again, just to recap, today was the day the appellate court was pronouncing itself on the BBI case, and like it stands, it has been thrown out. Whether it will proceed from this point on or not, it remains to be seen, because then again, it depends with those parties that were concerned with the matter. So it is an issue, it is a matter that we will continue following closely, even as day breaks, even as days go by, even as we inch closer to the 2022 general election. Wanjiru.
Thank you so much, Philip Murutu, and he has been following up closely on that with the rain. But thank you so much for that outline on the process of BBI. That has been Philip Murutu. He is at the Court of Appeal there, following closely on the verdict or the moment of truth that is finally out. BBI has been rejected or dismissed. And of course, this is the BBI judgment that has been going on since morning, where a 7-judge bench got a chance to, read out their arguments on this particular BBI, or the Building Bridges Initiative process that was declared unlawful. The Court of Appeal did affirm that BBI is unconstitutional and unlawful, and of course in a majority decision by the 7 judges, the process was declared, the 7 stages were declared unlawful and unconstitutional. And of course, earlier on, he did talk to Senator Irungu Kang'ata, and of course, Irungu Kang'ata just saying, or previously, just saying that he did warn on matters BBI, and to some extent the Jubilee chairperson David Murathe also saying that he did partly agree on that, what was said there by Senator Irungu Kang'ata. But of course, the big question now being, what does this mean for the people of Kenya, of course, the opponents and the proponents of this particular bill. But of course, we will be speaking to Arnold Maliba. He is right here in the studio with me. He is a political analyst, and he will be getting to explain to us so that we can get a more understanding on what this verdict means for the people of Kenya. But for now, we take a short break right here. We will be back with our 10 more.